Thank you very much. Appreciate you all being here today, and for any of our guests that are with us. The roll call, if you would please respond with a verbal present or something similar. Virginia Harris, the Vice Chair.
Present.
Karen Bennett, State Representative. She, by the way, she may be listening. She has not a little under the weather, but we did talk earlier today. Claudette Leaks.
Here.
Mary Hinkle.
Here.
Lance Hammond.
Here.
Karen Carter. Robert Wittenstein.
I'm here.
Susan Nugent.
I'm here.
And Bobby Sanford. Dr. Gerald Austin, our new member. He's here and muted, but I can see him. So
I'm here.
thank you. Clara DeLay.
Here.
Thank you. Jim Grubiak.
Here.
Dwight Thomas with the sun over his head. Is he here? He's here.
Yes.
Thank you. Vicki Turner. And ex officio members, I know Carla Drenner had a conflict. Carla Drenner, State Representative. Emmanuel Jones, State Senator. And John Turner also contacted me that he's continuing traveling and he's an alternative for the House. Thank you so much for being here. Any other commission members look like they came on board? Not seeing any. Okay, the minutes from the previous meeting earlier, Mr. Williams sent out to you a transcript. And when they originally said they were going to transcribe the meetings, in my mind, I thought we would be provided minutes, and I was wrong. There was an actual transcript, so there's no real need. It's a verbatim transcript of our last meeting. There's also a video recording of our last meeting that's on the county webpage. We don't need to actually approve these minutes because there is a transcript, and it's too detailed for you to probably edit at this time. But look over it if you see any corrections or anything wrong. There shouldn't be, but we would certainly go back and make those adjustments. In our future meetings, Mr. Williams has provided a member from the clerk's office, DeKalb County Clerk, and DeKalb County Clerk Ms. Saunders is going to be taking minutes for us in the future. I figured minutes would be easier to review and see than going over the entire transcript, also for the public. So we'll have minutes for the next meeting that will need to be reviewed from you and make sure all the nuances and subtleties are there to include what our intent is. So my apologies for that, but the minutes will be available next time. And today we are blessed with the county attorney. I hope that maybe we can do this in a couple of meetings, maybe we can't, but we have some bylaws to look at, election of secretary, and we have Mr. Metelsky to also present. So I'm thinking about an hour or a little longer, for an hour and 15 minutes or so at the most, for Ms. Ernst to go over the meeting. If you get more than halfway through, kind of let us know if you think you're running through it real quick, and we'll spend a little more time on the bylaws and save some for next meeting. But I mean, if we go all the way through, that's fine. If we're 1/4 of the way through, that's fine. So thank you very much. Vivian. DeKalb County Attorney.
You're on mute, Viv.
I'm sitting here talking as if you all could hear me. Good evening. As most of you all know, I'm Vivian Ernstis. I'm the county attorney for DeKalb County. I have with me this evening Terry Phillips. He is one of the deputy county attorneys and will be assisting me with the Charter Review Commission. Before we begin, I need to make sure. I noticed that there were two members, Ms. DeLay and Dr. Austin, who I do not have email addresses for the two of you. I sent out a copy of the Organizational Act and a copy of a House bill this morning to all the members, and I'm going to be using that. I'll be sharing my screen with Mr. Metelsky, but I'd like to be able to forward that to you at an email address. If you would prefer to put that in the chat for this Zoom meeting.
We don't have it. There's no chat
okay.
or Q&A for this meeting.
Okay. I can give you my email address and you are welcome to email me so that you don't have to put an email address out into the public sector. It is V Ernstes, ERNSTES. So that is VERNSTES at DeKalb County, all lowercase, ga.gov. And I will make sure, Dr. Austin and Ms. DeLay, that you all are added to the roster for future emails.
Thank you.
Thank you.
All right.
One thing, Vivian, before you start, and I should have mentioned this, we're going to be kind of easy and free going with this, so you all know if you want to interrupt the county attorney with a question at the time she's talking, you can. If it becomes where it's too much or we're slowing down too much, then I'll say something and we'll try to save things. If you can and you don't think it's necessary to be brought up at that instant, then save it as she finishes each section and maybe go back over the questions that you scribbled down. But if there's something right there that you need clarification with, we're going to try to make this as free and easy as we can to make sure we get clarity on the charter. Thank you.
Mm-hmm. And I will stop at the end of each section and ask if there are questions, but certainly if you have issues as I'm going through a particular section, I'm used to being interrupted. I do board meetings every Tuesday. So that is something that I am very comfortable with. What I sent you this morning, and Mr. Metelsky, I don't need you to share the screen quite yet. I want to give the Charter Review Commission a little bit of background. So I sent you a document that was 39 pages long, which is the codification of the Organizational Act of DeKalb County. And I sent you a House bill, which is the redistricting House bill. And I'm going to talk about that bill as we go through the Organizational Act. But before we do that, I want to sort of talk to you about the legal structure of laws in Georgia. And the reason that I'm doing that is so that you can understand some of the citations and some of the issues and how laws are amended, particularly how charters are amended. I know there are a number of attorneys on this call and also very sophisticated professionals, but if you do not practice local government law, this structure is perhaps not familiar to you. And so if you'll bear with me for just a few moments, when you think about the laws in the state of Georgia, you start out with the Constitution of the state of Georgia. That is the guiding document for all law, for all the state, all branches of government, all cities, all counties. Beyond the Constitution, then there are laws which are considered of general application. What I mean by that simplistically is they are laws that apply to everyone, okay? So they apply to most counties, most cities, they apply to the state, they apply to the judges. And those laws you are going to see cited throughout this charter. They are referred to as the Official Code of Georgia Annotated. So when we go through this charter, you will see an abbreviation. It's OCGA. And that's what that refers to. And if you're doing this, they come in a little red and black book. There are a set of 45 of them. We all use them every year after the General Assembly is finished. Then the codifier, which I think is West or Mitchie, comes in and updates the books, okay? And the books are updated and we get pocket parts and they're dated 2019 edition. And so when I talk about OCGA laws, oftentimes these laws apply to counties beyond DeKalb. So for example, there are a number of laws that apply to elections. Those are most often found in this book because they apply whether you're in DeKalb, Gwinnett, or Fulton. The third set of laws that most folks are not very familiar with are what are called local laws. And oftentimes folks confuse the term local law with an ordinance. They are different. In Georgia, a local law is a law enacted by the General Assembly and applicable to either one county, one city. There used to be population laws, one entity. And those local laws, your charter, this organizational act is a local law. That local law is found in, see these beautiful red and gold books. They are by year, right? They are not codified or updated by the state. So you have from, I think I've got in the library right now, from about 1949 to 2020, 2021, I think is our last one. And all of those laws are the laws that we are going to be talking about in this Charter Review Commission. The final set of law that you all talk about is what are called ordinances. Ordinances are those laws which are enacted either by a city, but in this case, by the Board of Commissioners in their legislative function. And in Georgia, and this is true in DeKalb and true in other areas, the local law and the ordinances are codified. There's a company called MuniCode, and they codify and they put them all in one big book. And some are just reprints. So your organizational act, your 39 pages, I reprinted from MuniCode. But the actual law is each session law, each book. And so there is, they date back to 1947 for DeKalb County. 1956 is the law that is sort of the beginning law for this Board of Commissioners and CEO form of government. But I wanted you to understand the difference as we went through it, because different manners of amending those local laws exist, and different manners of dealing with the official code of Georgia exists. So normally and typically, a local law has to go through your delegation. There has to be some publication rights, notices before an act can be amended. And in the case of the charter, as I explained to you all at our first meeting, there is a referendum requirement. And the referendum requirement arises because the genesis of this charter is a 1978 constitutional amendment. And I'm going to create a notebook of all of the local laws for you by year. And I will include the 1978 constitutional amendment. Ms. Leek, this was you asked for the 1956 law. It will be included in that notebook. I just did not want to overwhelm you all with paper today and wanted to sort of work through the codified version. But I will provide you with a bound notebook that includes each of the laws since 1956 forward that affect the Board of Commissioners, so that you can actually look at the words on the page from the act itself and see the changes through the years. So with that, I'm going to start with Section 1 of the Organizational Act.
Excuse me, Ms. Ernstes, if I may, and Chair Hansen, I believe the CEO has joined us and may want to speak, and I'll defer to the chair if that would be appropriate at this time.
Absolutely. We're always glad to have the CEO, and glad he was able to join us. Do you have anything, Mr. CEO? Mr. Thurman?
CEO Thurman, you are unmuted.
Yeah,
There you go.
yeah. No, Mr. Chairman, I'm fine. I'm just mesmerized by the county attorney's presentation. So
I don't know that mesmerized is the right word, sir, but thank you.
We're just grateful she's on salary and not hourly.
That's right.
And Madam Attorney, which one would you like me to share first?
What I'd like you to share is page 1 of 39, Mr. Metelsky. Nope. There you go. And if you will scroll down so that the Charter Review Commission can see both A and B of Section 1. Yes, perfect. You will stop right there. All right. So Section 1 of the Organizational Act of DeKalb County is a very simple section, but it is also very important. And the reason that it is important is that it defines the term governing authority. And while that may not be instructive to you when you go back to the OCGA and the Official Code of Georgia and you look at the laws have been written to use the term governing authority of a county. And so this section is incredibly important to define that governing authority. And the first thing is the first paragraph defines the Board of Commissioners and to be elected and organized as hereinafter provided, which means as provided in the Organizational Act. The second sentence talks about the creation of the Office of Chief Executive Officer. And what is important about that for you all to know is the phrase, who shall not be a member of the commission. So by law, the Chief Executive Officer is not a member of the commission. He is not a member of the Board of Commissioners. He is elected as provided in the Organizational Act. In order to guide and be precise throughout the rest of the Organizational Act in Section B, the Board of Commissioners is referred to as the commission, and the Chief Executive Officer is referred to the Chief Executive. The important sentence for you to understand, the portion of that sentence, is that together, the CEO and the Board of Commissioners constitute the governing authority of DeKalb County. And the final phrase tells you that the duties and powers of each are provided in this Organizational Act. And here is my cheat for you. Do you see where it says Acts 1981, page 4304, section 1? Members of the commission, when you get my notebook, that will tell you to open the tab to 1981. You'll go to page 403, which I will have copied for you, and that will show you section 1. And so as we go through this Organizational Act, presumably all of the times that that particular section has been amended or changed should be in that legend. So if you want to go back and look at the various provisions of the various acts enacted by the General Assembly, you would use that legend. And so what that tells you is that that section of the Organizational Act has not changed since 1981. So it has remained unchanged since the original Organizational Act was enacted. Does anyone have any questions about section 1?
Not seeing any hands
Hinkle?
raised at this time. Oh,
I think Ms. Hinkle has her hand raised.
no.
All right, then I will move to section 2. And if you will pull section 2 up, Mr. Metelsky, so that the Charter Review Commission can at least see A, B, and C. That's perfect. So as we go through this, I want the section 2, subsection A, the commission shall consist of 7 members. That is self-evident. Sections B, C, and D will be amended by the enactment of House Bill 1250, which I also sent you this morning. As we talk through this, B, C, and D are the census redistricting sections. All right. And the reason they have not yet been amended is because in House Bill 1250, and Mr. Metelsky, if you could shut down this screen and pull up House Bill 1250 for me, I would appreciate it. All right. So House Bill 1250 is and if you would go all the way to the end of it, sir. The end of the document. Oh, excuse me, to page 5 of the document. I forgot there were all the census numbers. All right, so and if you'll go up just one little bit more, sir, effective date, there we go, section 3. So the reason B, C, and D have not yet been amended in Muni Code is because the provisions of House Bill 1250 became applicable to conduct elections for the members of the Board of Commissioners. As you know, there were elections recently for at least primaries for Commission District 3, 7, and 2. But the remainder of that section, if you'll scroll down one more page, sir, does not become effective until January 1st, 2023. So members of the Charter Review Commission, instead of going through B, C, and D, which are going to be obsolete in months, I thought that I would just go through House Bill 1250 instead so that you could see what those changes will look like come January 1st, 2023. So, Mr. Metelsky, if you will return to Section 1 of House Bill 1250. And for the purposes of the commission, this is a technical section. It is written to align with the redistricting maps adopted by the General Assembly. So a number of the provisions in this section are provisions insisted upon by Legislative Council. They are for the purposes of ensuring that the districts are defined in compliance with applicable law and clear for the purposes of voting. So if you look at Section B, it's relatively self-evident. It tells you that there are 7 commission districts. There is 1 member of the board elected from each such district. B1, and I do not have the Appendix A and the maps, but those, I didn't think that you needed to see them. They are, B1 tells you that there are 5 commission districts. They are numbered by reference to a particular map adopted by the General Assembly in compliance with the census of 2020. And then for the purposes of the plan, 2 is a definition of what the word VTD shall mean in the Bureau of Census. And subsection B, 2B, if you'll scroll down a little bit more for me, to B3 and 4 are the sort of what I would say the legalese language that is needed to ensure that our maps are in compliance with law. It is complicated. I'm not sure that it is anything that you would be particularly interested in terms of the work of this charter commission. And that is true for everything through the end of that section. And Mr. Metelsky, if you'll continue down to the bottom of page 3 for me. But if there are questions, I will try to answer them the best that I can. I will confess that I am not a redistricting census lawyer. If you'll stop at section 3, sir, I'm going to ask you. But if there are questions, I will be glad to take questions on those 3 sections when we get to the end. And I may not have the answer for you today, but I will come back to them. Mr. Metelsky, if you will return to the Organizational Act, section 2. Excuse me, let me get you to the right page, sir.
Can I ask a quick question?
Sure.
You talked about the 5 commission districts. Where does it talk about our super districts? Is that?
Yep, it is in here as well, sir.
Okay.
And let me tell you the exact section. It is at the top of page 3 of House Bill 1250. And it says Commissioner District 6 and 7 shall be and correspond to those 2 numbered districts described in Appendix B, attached to and made a part of this act, and further identified as user, DeKalb plan name, DeKalb CC, Super 2022, plan type local. So it's at the very top of that page.
Ms. Ernst, so is it not true that this bill was to correspond to the other areas of the Charter Organizational Act that state that there'll be 2 super districts? Or, there was talk about changing them to local districts, but they felt that would need to be a referendum because it was a change of the charter. So there must be other references in the charter outside of 1250, House Bill 1250 that refer to super at-large districts.
Yes, sir, there is.
Okay, thank
There
you.
are other provisions. So, Mr. Metelsky, we have gone through, if you would go back to the Organizational Act to the top of page 9. So the good news for you, members of the Charter Review Commission, we just skipped through about 6 pages, which are all the numbering that is needed. So we've moved ahead. We've gone from page 2 to page 9. What I'd like to show you is subsection E. So subsection E was not changed by House Bill 1250. And it is the subsection that defines the qualifications to serve as a commissioner. And so as you can read in subsection E, you have to be a citizen of the state. You have to be at least 25 years of age. You have to be a resident of the geographic area encompassed by the district for at least 2 years immediately prior to taking office. Provides that each commissioner shall be elected by a majority of the electors voting within the respective commissioner districts. And the sentence I want to draw your attention to is the next sentence. It says, except for displacement of their residences from their respective districts due to reapportionment of the districts, any commissioners who cease to be residents of their respective commissioner districts during the terms of office shall thereby vacate their seats on the commission. So one of the things that I really enjoyed about preparing for this evening was I got to sit down and read the Organizational Act with no particular purpose in mind. And what I wanted to draw your attention to, that phrase about the displacement of their residents from their respective districts due to reapportionment, was somewhat of a surprise to me. I had forgotten that. I have not seen that in other areas. I do think that arose out of redistricting back in the early 2000s. And that is an interesting phrase and might be something that you all might want to look into. The final sentence is extremely important because it is what I talk about when I talk to you about the official code of Georgia. It says all members of the commission shall be nominated and elected pursuant to the provisions of Chapter 2 of Title 21 of the OCGA, the Georgia Election Code, as now or hereafter amended. This evening, I'm going to make very few suggestions for changes. That is your role. That is outside my lane. But one of the suggestions that I am going to make is as we refer to OCGA, there's a very important phrase that is very useful for lawyers. That is the phrase as now or hereafter amended. And that means that whatever version of the election code is in force at the time you are using that particular section, that version of the election code applies. And so one of sort of the housekeeping changes that I would ask that you all consider is every time there is a reference to OCGA, we ensure that it is followed by the phrase as now or hereafter amended. All right,
Before we move on, can I just put one quick thing out?
Sure.
This is Robert Wittenstein. One of the other things we might think about as a charter commission is the phrase that elected by a majority of the electors. You know, what that requires is runoff elections. And one of the things that may have come out of style since this was written was the idea that the best way to figure out who ought to be in the final election is somebody who's got 50+1 that requires a runoff. And we might at least think about setting a lower bar to avoid runoff elections in which often the turnout is so small that you don't end up getting the person who can be most representative. I'll just throw that out as food for thought.
Jim, does state law require plurality or, a 50+1 for county races? I know for legislative seats.
Senator Henson, I think that is correct. But that's one of the notes that I have made. If I cannot answer a question definitively, I like to be precise. Then I have written that down for you all, and I will report back on what the state law requires in this regard. But I do believe that there are members of the Board of Commissioners who have discussed this potential provision as it relates to other races as well, and may have been part of a legislative agenda in 2022. But I will go back and check that, Mr. Wittenstein. And if there is state law that affects this issue, then I will report back on that.
Ms. Grubiak, did you have a question?
Vivian, would you explain what the effect of that term is, or that references to the displacement of their residences? I'm not sure what that exactly refers to, or what the effect of that language is.
Is that the 2 years, or does that mean that their district doesn't continue?
So it's I think, all right. So again, that language is not the model of clarity, and it certainly doesn't define when you would have to leave office. But in layman's terms, what I think that says is when you are drawn out of your commission district through redistricting, through a census, that you don't your office is not immediately vacant.
It's not immediately vacant.
It's not.
Often the districts continue in a shadow form until the next election of office. We might need to look at that, because there's also a little confusion. The 2-year residency, you can actually lose your 2-year residency during reapportionment too, although that would be rare, and you'd have to be uniquely elected as kind of a special elections kind of thing. But from your district, but that you're right, it is confusing. That's probably something we do need to look at, commission members. Thank you.
And I will also look at is whether the 2-year residency has been changed through OCGA, through state law, whether there is a different residency requirement. I don't know that it has, and I don't know that that would have been changed by general law. But I will look at that and report back. So this is a good example of what I call my cheat sheet. It tells you the number of times that this section has been amended, and you will get copies of each of those bills. So as I understand from at least now, and I'll open it up for other questions, the 2 issues that you have asked me to look at, and I think the commission is going to look at, is whether there is any general state law on the requirement that there be a majority of the electors to elect a commissioner, and to look to see if there is this displacement of residences in other areas, if that is standard language used in other charters or organizational acts. And then I have offered to look at whether the 2-year residency is changed or has been changed since 1981 to a 1-year residency. Something in the back of my head says that it may have been such that you may not have to require 2 years, but I will report back on those 3 questions, and I will open it up if anyone else has any questions.
I'll just make a comment. The state law for legislative seats is a year from the general election proceeding. So, when the attorney gets the information there, hopefully too, as we'll talk later, we'll probably get some staff that'll help us and help the county attorney too on some of these issues for us. So thank you.
And when I cite to general state law, so that you don't have to go find it somewhere, I will give you all copies of it. And I'll highlight the section that I am referring to. So I'll send those by PDFs so that it's easy for you all to see. And if it is subject to more than one interpretation, I will try to advise you of that.
Just for clarity from my perspective, when you say reapportionment, you're talking about the census that happens every 10 years?
Yes, sir.
Okay, so this would only come into effect every 10 years.
Yes, sir.
Okay.
Absolutely.
The reapportionment can be created by legislative action, not every 10 years, but that is normally correct.
Thank you, Senator Henson. I had forgotten that you could do it outside of the census. So Mr. Metelsky, we are moving to section 3, which is establishment of the commission. And if you would pull that up as much as you can. So this entire section, A, B, C, and D, is going to be replaced by section 3 of House Bill 1250. And you had asked earlier where the super districts were talked about. This is one of the sections which talks about super districts. So instead of looking at the bottom of page 9 on the Organizational Act, I would like, Mr. Metelsky, for you to go to section 3, and it is the top of page 4 of House Bill 1250, please. All right, so what it tells you in A is that all 7 districts as they exist immediately prior to the effective date of House Bill 1250 shall be continued to be designated as 1 through 7 respectively. Excuse me. But as newly described under the act, and the description is based on the maps and the 9 pages that we got to skip over the VTDs. And provides that the members of the board serving from those former districts shall be deemed to be serving from and representing their newly defined districts. The section B is a technical section that says those who are serving on the effective date and any person selected to fill a vacancy shall continue to serve as such members until the regular expiration of their respective terms of office and upon the election and qualification of their respective successors. That is a relatively normal phrase to define when you leave office and when you take office. Section C and D update those sections of the Org Act to provide for new election dates. What they are is they provide for staggered elections of commissioners such that you don't have, that is also a very normal drafting technique, so that you don't have a whole new member board of commissioners every single time you have every 4 years, so that you have some institutional knowledge and some new elections. So 1, 4, 5, and 6 are elected, will be elected in 2024, and 2, 3, and 7, as I told you earlier, will be elected in November of 2022. This section E is this is also a very standard technical section that defines when folks take office. There have been very few problems in DeKalb as to when somebody takes office because it's pretty well known. It is the first day of January immediately following their election, and they shall serve for terms of office of 4 years each. All of these sections are needed just to put in place how long folks serve in their office. When they take office, they must take an oath before they take office, and that just create some sort of finality and definiteness. There is a catch-all provision at the bottom. Mr. Wittenstein, did you want me to stop so that you could ask a question, sir?
Yeah, I'll just point out for the commission that when the city of Dunwoody just did our charter review, we changed this section from the first day of January to the first regular meeting in January, just so we didn't have to have a meeting on Sunday, January 2nd. In order to swear in our new elected officials. And instead we could, we could do it at the first regular meeting. That might be something for us to consider if we did, it was just very awkward the last time we had an election that we had to have a city council meeting on Sunday, which happened to be the first day of January immediately following the election. And so that might be something we would at least talk briefly about.
Yes, sir. Members, the final sentence is just a reaction to the fact that Members of the board shall serve for terms of office specified in this subsection and until their respective successors are elected and qualified. So again, if you all have any questions on this section. All right, don't see anyone. All right. Section 4, this is the one section, if you will go back to the Organizational Act, Mr. Metelsky, and it is page 10 of 39. So section 4 is the section that defines how and when and what happens if you decide, if you as a Board of Commissioner, as a member of the Board of Commissioners or the CEO decide to run for a different elective office. And section A defines that essentially if you decide to run for something besides your original seat on the Board of Commissioners, or you decide to run for an elected office other than being CEO, if you decide, you've got to resign from your office. And it refers to section B and C. And that's a concept everybody is somewhat familiar with, is if you decide to run for a different office or to qualify to run for a different office, there's oftentimes that you've got to resign from your current seat. Section B and section C define in a very sort of complicated manner a resignation on April 1st and a provision of when the office is considered vacant. This B and C were the subject of a lot of debate in 2000 when a member of the Board of Commissioners decided to run for CEO. And I will tell you that is before I started work with DeKalb County, so I don't have any independent knowledge of the issue. I only have institutional knowledge. And it became an issue raised by the Secretary of State and actually ended up in an Attorney General's opinion governing when that commissioner had to resign from office. And the reason that B and C became problematic is they conflicted with a provision of the Georgia Constitution that is very complicated, that defines when you must resign from office if you are seeking a different elective office. Now, I recognize, and everybody on this call knows, that lawyers give opinions. You want a ruling, you go to a court, right? So I give opinions all day long. The Attorney General gives opinions all day long. You want a definitive ruling, you go to a court. But what I would like to do, if you would allow me to do so for a future meeting, I would like to send you this AG's opinion. And I would like to be given the opportunity to revise this section so that it complies with the constitutional provision. And unfortunately, every time one of my elected officials decides to run for an office, I have to go back to the constitutional provision and we have to parse it word by word. But and it ended up that as a result, during the 2000 election, that commissioner was deemed to have been, to have created a vacancy upon qualifying to run for CEO. So I really feel pretty strongly that B and C need to be considered in light of that AG's opinion and in light of the constitutional provision, which is found. I'm going to send you this AG's opinion so that you have it. And so that you can see it. But the B and C, I do think it's one of the few times that I'm going to suggest that those two provisions be revised. I will send that AG's opinion tomorrow. I didn't want to send it today. Again, I didn't want to overwhelm folks with paper this morning. So I would prefer that we delay B and C, but I will be glad to try to answer questions about B and C if you have any questions about them. And if you would like to wait until you've seen the AG's opinion and compare that to the section, that would be fine as well.
We-
This
we-
rule,
Go ahead.
I was just gonna ask this rule about you have to leave one office to run for another. That's specific to our organization act. That's not, because at the state level, they can keep their office and run, right?
It depends.
Okay,
It depends on when the office starts and when the office ends.
so this
Are you
is,
saying, is there reference in the state constitution about leaving offices and running one from one office to another?
Yes, sir, there is.
So that does affect our county commission races. So
Yes.
I think what she is stating, that's leaving office when you run for another. Years ago, it was the Zell Miller change. Zell Miller ran for U.S. Senate and state lieutenant governor. There was changes, but I think it's a constitutional thing. She wants our county act to conform with the state constitution. So we appreciate that recommendation, because anything we as a commission decide on will have to go to the General Assembly. And certainly they can't pass anything in conflict with the state constitution. They want to change that, that's 2/3 vote. So we're probably going to try to make everything coincide with the state constitution as much as possible.
And specifically, the Georgia constitutional provision is at Article 2, Section 2, Paragraph 5. And it reads, the office of any state, county, or municipal elected office shall be declared vacant upon such elected official qualifying in a general, primary, or election special for another state, county, or municipal office. And this is the phrase that's very hard to construe, and we have to look at it every single time. The phrase is, if the term of office for which such official is qualifying for begins more than 30 days prior to the expiration of such official's present term of office. And so one of the things that I see Ms. Hinkle shaking her head. I do it every single time. I would suggest that we refer to the Constitution and that they will be declared vacant in accordance with the Constitution as it exists now or is hereafter amended. And that way you all don't have to spend time trying to figure that out, since it is figured out in the constitutional provisions of the Georgia Constitution. Ms. Hinkle, you had your hand raised.
I guess want to point out that there's no discussion at the of the commissioners in terms of term limits. And so I just would like to put that on the table as an item of potential discussion in the future, if we're considering term limits for the Board of Commissioners. So.
Yes, ma'am.
Thank you.
And Ms. Hinkle, when I get to the term limits for the CEO, I will draw attention to that for you so that you can see where that is addressed in the Organizational Act and how it is addressed. All right. Excuse me, hold on just 1 second. We are moving to Section 5. Section 5 deals with the CEO. So the requirements, the age requirements for CEO are 5 years more than the age requirements for Board of Commissioners. Board of Commissioners is 25, CEO is 30. The residency requirement is 5 years instead of 2. Again, to Mr. Wittenstein's comment, the CEO is also elected by a majority of the electors. So if you were able to consider something different in light of the state law, this provision you should also consider a change to this one. And again, the CEO is nominated and elected pursuant to the Georgia Election Code as now or hereafter amended. This defines the terms of office for the CEO and defines that he is serves a term of 4 years, and each CEO is served until his successor is elected and qualified. Ms. Hinkle, subsection C is the term limit for the CEO, and it is a limited term limit. So as you read subsection C, this is another area I wanted to point out to you that is perhaps a little bit different than what the layperson thinks about term limits for the CEO. So it is, you are elected for 2 full consecutive terms of office. And the important point in that sentence is the word consecutive. All right. The final sentence says, when a person has served 2 full consecutive terms of office as CEO, such person shall not again be eligible to hold said office until he has been out of office for at least 4 years. So you can run for CEO again once you have been out of office for 4 years if you have held 2 full consecutive terms. That is the term limitation for the CEO, and you will see that has not been changed since 1981. Are there any questions about section 5? All right, I'm going to move to section 6. So section 6 is the other section of the Organizational Act where I am going to ask that you make some changes because of relatively new state law. So it used to be, the law used to be until, let me look at this, until sometime in the early 2000s, used to be that you could hold a special election whenever you wanted to. And most of our legislation allowed you to do it with 15 to 49 days notice, 45 days notice. You issued the call, you held the special election. Well, at some point, the General Assembly decided that special elections didn't need to be willy-nilly all through the calendar. And so the General Assembly enacted a general law, section 21-2-540. And it defined when special elections can be held in Georgia in odd years and even years. And so these term dates in B and in B, in terms of when the special election shall be called and held, are no longer valid. And they just need to be amended so that they are in compliance with section 21-2-40. So for example, in that code section, and I'm going to send this to you, in odd number years, you can have a special election on the 3rd Tuesday in March, 3rd Tuesday in June, 3rd Tuesday in September, or the Tuesday after the 1st Monday in November. So you're not limited to just one day a year. There are a number of days, but that provision in section B, which is, I believe, the first and second sentence, will need to be revised just so that it is in compliance with the state law that came into effect. All right, so going back to section 6, and I'm going to go back to section A. There has been some question in the recent past about temporary vacancies. As you all know, we did have a former CEO who was suspended during a period of time when he was under criminal indictment. He was not permanently removed from office. And section 6 does not address in any real way temporary vacancies. And so as you all look at this, you may want to look at that issue for the future. But I'm going to go through the section the entire section and tell you a little bit about what it says. So vacancies on the commission are in the first deals with the CEO. Death, resignation, removal from the county, or for any other reason. And that's where it sort of addresses temporary vacancies when it says for any other reason, but it is not specific and precise. And it says they shall be filled as provided in this section. So this is relatively typical. You see this in a number of other offices in the state. If there's more than 180 days left on the term, then there's a special election and another person is elected to serve as CEO. And so that's what the first couple of sentences in B say. The last sentence in B that starts with, if the vacancy is in the office of CEO, then what occurs is that the presiding officer of the commission he doesn't become, or she doesn't become the CEO. They simply are given the authority to exercise the powers and duties of the chief executive, with at least one limitation, which we'll get to at the end of this section. And that period of time begins on the date of the vacancy and ends when the new CEO takes office for the unexpired term. Subsection D deals with a vacancy in the office of CEO with less than 180 days. And, there we go. And what that says is if there's less than 180 days, the presiding officer of the commission fills and serves as CEO. He exercises the power of CEO until the end of the term, and has all of the powers of CEO except for one power, which is set forth in subsection E. In the event of a vacancy on the commission, and vacancy on the commission is defined again in subsection A above. So it talks about resignation, death, removal from the district, or for any other reason. And if less than 180 days remain on that office, the remaining members of the commission shall appoint a qualified person to fill such vacancy. Now, the person who's appointed has to possess the residency and qualifications of the office, but that section gives the power to the remaining members of the Board of Commissioners to fill the seat for the remaining 180 or fewer days on the commission.
Madam Attorney, through the chair, Ms. Leek has a question.
Yes, ma'am. Thank you. I can't, while I'm going through this, I can't see your faces. So thank you, John.
Okay. My question is it anywhere in this section, I was trying to read through it, but is there anywhere where that it addresses what happens when that presiding officer fills a vacancy, CEO vacancy?
No, ma'am, not in this section, but that issue is addressed in section, let me get to it for you just a second. It is partially addressed in section 11, which we will get to.
Okay.
What happens in that situation? Okay.
Just a quick question before you move on. If there are more than 180 days left in a commissioner's term, then at that point, would you have a special election?
Yes, sir. And I didn't mention that. If you, Mr. Metelsky, if you go back up to B, I focused on CEO, but if you'll go, just move me back up just a little bit. It says in the event of a vacancy on the commission or in the office of CEO with 180 days. And Mr. Hammonds, thank you. I forgot to mention that that vacancy of longer than 180 days triggers a special election. You're right. So coming down to subsection E. What subsection E tells you is that if the presiding officer exercises the powers of the CEO, then he is the one power he is not allowed to do. He is not allowed to discharge the executive assistant. So the executive assistant is a term that is used in DeKalb. I haven't seen it used in other areas. A lot of folks think of an executive assistant as an executive administrative assistant, someone who runs your office. Executive assistant in DeKalb County refers to Zach Williams. So it is the chief operating officer. Oftentimes in other counties, you hear them referred to as the county manager. We're going to talk about the executive assistant. The executive assistant and his duties are defined in the Organizational Act later on, but that is the one power that the presiding officer does not have. He or she cannot discharge, i.e. what that means is can't fire the executive officer. The other thing that the presiding officer cannot do while he is exercising the powers of CEO is he can't vote as a member of the commission. He can exercise the right of veto, but he cannot vote as a member of the commission. And you will note that this section of the Org Act has not been changed since 1981 either.
And
Anybody-
Vivian, under the present status for the CEO, if he fires the chief executive officer, does he have to get commission approval, or can he dismiss him for the regular CEO position?
We will get to that. That is actually defined in the Organizational Act. The regular CEO has the power to discharge. We're going to talk about me at some point as well. The CEO, let me be precise. The elected CEO has the power to discharge the executive assistant and the county attorney. The Board of Commissioners, by a vote of 5 members, also has the power to discharge the executive assistant and the county attorney. I think Ms. Hinkle has raised her hand as well.
You're on mute, Ms. Hinkle.
John, will you take down the screen share so I can see folks as I'm talking to them? Thank you.
Okay, I'm unmuted. Okay, so in this instance, if he or she can't vote as a member of the commission, then essentially their district is unrepresented in planning and zoning votes. Am I right in saying that?
No, well, Ms. Hinkle, assuming that your Board of Commissioners can't decide on who to appoint to fill that position.
Oh, okay.
So subsection D, if there's less than 180 days left on the term, the Board of Commissioners, by 4 votes, official action, raises their hand and says, Vivian Ernstis is now going to be a member of the Board of Commissioners. And then I have the right during that, till the expiration of that term, to act as commissioner, assuming that I meet the qualifications and that I live in the district.
Okay. And otherwise, if it's over 180, we would be having a special election.
Yes, ma'am.
Okay, thank you, Vivian.
And Ms. Hinkle, in terms of zoning and planning, don't forget that if you have both a district commissioner that represents that area, but you also have a super district commissioner who is, both of those are responsible for planning and zoning.
Madam Attorney, Mr. Hammonds, followed by Mr. Wittenstein.
Perfect. Mr. Hammonds?
So if there's a vacancy in the CEO's office and the presiding officer moves up, is his title or her title still presiding officer? Or are they acting CEO? What
we did in the past, sir, is they were called interim CEO.
Okay.
It's not, there is no definition in the Organizational Act as to what that term would be. The reason that their title is no longer presiding officer is, and I will get to that when we get to section 11 on presiding officer, there is a provision for the deputy presiding officer to step into the shoes of the presiding officer. So that's why that term would be confusing.
Okay, thank you.
And Mr. Wittenstein?
I'm not
Then I
sure
think
your-
Representative Bennett.
Yeah, I'm not sure that your answer directly answered what Ms. Hinkle's concern was. It's
Okay.
clear that if a commissioner resigns, the commission has the power to replace that commissioner if it's within 180 days, and there'll be a new representative there. But if the presiding officer becomes temporarily the acting CEO, they no longer get to vote, and the commission isn't in a position to replace that person because they haven't vacated their spot yet, right? So they are actually off the commission as a voter, but there is no way to fill that position So that position does stay vacant. I think if I read this correctly, there isn't an opportunity for you to disenfranchise the acting CEO or the temporary CEO by having the commission replace them while they're on temporary assignment.
There is not a provision in Section 6 for a temporary assignment. That is correct. And if that is something you all want to consider, you would need to consider, Mr. Wittenstein, how in a lot of these situations, when a full-fledged vacancy exists, then a temporary assignment may make sense. But if it is simply what I would call a temporary vacancy, you may not have an appointment of some person to serve on a temporary basis. But technically, you are absolutely correct, sir. Good point. Which is why I also mentioned at the very beginning of this section that you all might want to think about temporary vacancies globally, right, as an issue, because I do believe there have been some questions in the past. I think Representative Bennett may have her hand raised as well.
I do. Thank you. Thank you, Madam Attorney and Mr. Chair. You may have answered my question. However, in the event of the fulfilling of the temporary vacancy for the CEO interim,
yes,
then an election comes. Would that person then have the opportunity to serve 2 full consecutive terms? Say if they completed an unexpired term of the CEO and then an election comes, because the eligibility for the CEO, the term limit is 2 consecutive terms, correct?
My guess is Vivian looks and knows what is right to tell you. My guess is that the interim CEO would not be considered a CEO. They would have 2 full terms through regular service.
Thank you.
Thank you, Senator Henson. You're a good co-counsel. I'll take you to court anytime with me. I agree with what he said.
Okay, thank you.
Ms. Ernst, too, just want to, I know as you look here at a good breaking point, certainly no time immediate, but we do want to reserve 5 minutes or so for the election, a few minutes to talk about our 10 minutes, maybe talk about our bylaws, and then a few minutes. I don't think Mr. Metelsky wants to take any of your time, so he'll probably be quick. But a good stopping point sometime in the next 15 minutes. Thank you.
So how about this? I will go through Section 7, which is the oath and the bond, and then I will stop at the end of that section.
That's great.
That's a relatively short section. And so this section may be another section that you all want to take a look at. What this does is define the oath to be taken by the CEO and the members of the commission. And that oath has to be entered before they begin to discharge their duties. And that oath is administered by the probate judge. And so there is, in accordance with applicable law, the oath is provided by the state of Georgia, by the Secretary of State's office. There is what is called a dedimus potestatum, which is a very fancy word for a piece of paper that they sign the oath that gets returned to the Secretary of State. And in addition to that, each member of the commission and the CEO are required to purchase and execute a satisfactory surety bond. So, Mr. Wittenstein, in distinction with the cities, the oaths are not done by the commission itself. They are done by the probate judge, and they are usually done a lot of times on the 31st, 29th, 30th, 31st, before the 1st of January. They are not required to be done in public. And there is a statutory process for that. But the area that you all may want to consider, and I thought would be important, and I have not provided you with these documents yet, but I will get them for you, is the amount of the bond. So if you look, this law was enacted in 81. It has not been changed since then. The surety bond for commissioners is 10,000. The surety bond for the CEO is 50,000. And I thought it might be of interest to you to know what that bond actually looks like. What does it cover and whether those amounts seem to make sense? So those bonds are purchased, and I will get you copies of those bonds so that you can know what they cover and see if any of those provisions need to be changed. If you do want to change the oath provision, I will, and if there are questions about that, I will need to look at that under prevailing general law. And so I'll be glad to look at that to see if there is a change that needs to happen with that. I have not looked at these bonds in a number of years, so I do not this evening have a good understanding of what those bonds actually cover. Mr. Wittenstein?
It would be really helpful to know if this is a common practice. This strikes me as a very odd thing to have a surety bond for an elected official. I'm pretty sure, Steve Henson, you didn't have to do one to become a state legislature, did you?
No, they didn't let me touch any money either, or give me a credit card or anything.
I'll be glad to look and see, sir. We can look at some of the other county commissions in Muni Code and their charters and see if they are required to have a surety bond as well.
Yeah, this seems like a very odd provision to me.
Okay, be glad to. All right, I will stop at page 11 and then we'll turn it, Mr. Chair, I will turn it back over to you. And we will, next time I am invited, I will start with section 8, which deals with compensation.
That's fantastic. I really appreciate that. So I thank all the members. Some of them might have wondered why we're going to read through the act, but I know myself, I read it, but now I'm getting stuff out of it. Now I'm understanding stuff a lot much more completely than I did when I just sat here and read it. So I think it's been a great exercise. I think it's one we have to undertake. And of course, we're probably getting more into some of the changes that need to be done here today. And that's a great thing. So really appreciate this. I think we're going to appreciate it at the future meetings. And hopefully anybody from the public watching is being educated a little bit on the issues that we'll be tackling. A couple things I just wanted to update you on is one, as you noticed today, we have one new member, Dr. Gerald Austin. Dr. Austin, say hi again. Hopefully he's still around, but he's a Steve Bradshaw appointment and lives in Karen Bennett neighborhood. So I know she can keep him straight if he causes any trouble. But no, we really are
happy to be here.
Oh, thank you. Well, we appreciate you serving. Then I wanted to mention a couple things. One, the future meetings. I had mentioned at the last meeting that we would try to meet the second Thursday of every month. And Mr. Metelsky can talk a little bit when he gets his chance to present, that I've been informed that we have to be accessible to the public, and we're doing Zoom meetings. So much like the zoning board or the elections board or the county commissioners, we have to be open to the public. And being a Zoom meeting, we have to therefore have the communication department be able to put us on the proper networks or live video or what have you. So there's really, I want to do it the second Thursdays. That's what I'd mentioned last meeting, after next month's meeting, July 20th, because we had a conflict with Vicki Turner on the school board on Mondays. County attorneys, of course, are preparing. They'd be willing to do it on Monday, but they're preparing for the commission meetings on Tuesday. Tuesdays, the commission's meetings start at 9, but they break and they come back. And 2 times out of the last 6 months, they've run past 6 o'clock. Plus the communication staff stays, starts at 5 o'clock. So it would be an awful hard and long day for them. It's possible we could do that, but that's a tough day. Wednesday nights, a couple of our members have church or other meetings there. So that was tough. So Thursday looked best. I want to do second Thursday. I was told by Mr. Mattel that clashes with the DeKalb elections office, which has that time period, and we can't do that. I then want to do the fourth Thursday, and he said that there's some problems with that in July. There's a zoning meeting already scheduled. August 25th, there's a special SPLOST meeting. September, we could do it, but October, then you have another special SPLOST meeting. So really, the first Thursday in August looks like the best time for us to have our meetings. So when we get to future meetings, I'll be proposing that we meet August 4th, September 1st, October 6th, November 3rd, and December 1st for the next several meetings. Now, when we do get into non-Zoom meetings, and if we go to meet at the Maloof Center or another public facility that has enough room for the public to come, then we don't have to be constrained by these conflicts. We could have a meeting at different times. So we'll always revisit this list. And if we see we have the dates that I throw out there at the future meeting at the end, we'll revisit it. If we can make changes, we will. But I just want you to be aware of those constraints. Secondly, as we've gone through this, and the county attorney has mentioned some things, for instance, plurality elections versus majority 50+1. There's a lot of issues resolved there. There's been issues in the past, both pro and con concerning racial equality and fairness. On those issues, there's been same things with that's plurality term limits. There's issues with that. And we probably need some help to work on that. As we discussed last meeting, as we brought forth a resolution about staffing, I just wanted you to know that I met with the CEO and Zach Williams for more than a couple hours. Most of that time, we actually did get a representative from Carl Vincent, 2 representatives in Institute to talk about staffing. We're all working together to make sure we have a good plan and a good recommendation. So I'm hoping maybe next week I can get with our vice chair and whoever we elect as secretary, sit down with the Carl Vincent Institute, talk to them, see if that's what we want to do. And the CEO and Zachary Williams are both very committed to spending what we need to do to have staffing and support. As the county attorney said, she's evidently doing some research in some of these areas, but we may want to have our own people do some research and do some study for us and prepare information for us. So also on the line, you can see there's a Charles Hankla who with GSU, they've also rendered some offers of possibly some time and talking to the CEO and all too about possibly some contract work with them. So by the next meeting, we'll have more on that. But I did want you to know that we have progressed, and the CEO and Mr. Williams were very generous in their input and their time in talking about that. And I want to state that they're very committed that we have the resources we need. Mr. Williams, you have any comment on that?
No, sir, Mr. Chair. I think you hit the nail on the head. As you indicated, the CEO has indicated that whatever resources are necessary will be provided, and I'm here to make sure that happens.
Sounds good. I know the CEO is still listening, but he's not shy. He'll weigh in if he wants to. Okay. If there's any questions about that, if not, I want to take a minute and now go to, let's see. Oh, I just want to thank Ms. Saunders, the clerk, who is taking our minutes, and I really appreciate that. And then now unfinished business. When we look at our order that was created by the CEO, he has us elect a secretary. So we have not done that at this time. Mary Hinkle had called and said that she'd be willing to serve. Haven't heard from anybody else, but this time I want for a discussion or even a nomination, or if somebody wants to offer their service, they can
nominate Mary Hinkle.
There's been a nomination for Mary Hinkle. Is there anybody else that wants to?
Second it.
Okay, Ms. Leek seconds it. Any further discussion or nominations? If not, is there a motion to close and make it a unanimous acclamation?
So moved.
Okay. Motion has been made and seconded. All in favor, say aye.
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 Ms. Hinkle, you have been elected by acclamation.
Thank you very much.
doubling the salary of all the other commission members. Thank you. Do you have anything you'd like to say at this time, since you didn't get a campaign speech?
No, I appreciate it, and I'm committed to doing this, and I will persevere. And as I told Steve Henson, I can be a nag, so y'all keep me in my place, because I will be persistent in getting the information that we need to get. So thank you very much.
One thing that Ms. Hinkle mentioned too on the phone is that when we do look at public meetings, trying to move out and find some places outside of Zoom, she would help look around. If anybody in those different commission districts, and we can do them on Zoom if we have to, but if you know of any good public venues around the county that would be wide open, that there would be space for the 17 commission members to spread out, as well as for the public to come and sit, but in a spread out fashion. If you have any suggestions or recommendations, contact the secretary or the vice chair and let them know. That would be a great help. Thank you. Okay. I want to go to the other unfinished form business is the bylaws. Earlier, back in 2019, there was discussion by a couple of members, or all the members actually, to have some bylaws. And 3 members went together and tried to draw some up. Mr. Grubiak is the only one of those 3 that remain. But they did a lot of work and did a good job. The purpose of bylaws is just to make sure there's clarity. We have Robert's Rules of Order that we pretty much operate from, but on certain issues, like for instance, if we actually want to recommend to the state legislature and the commission a change in their charter, we probably need a super majority, or make sure that we have a full, more than just half the members present voting. So you have to have certain special instances like that covered, and the bylaws will give us that. So originally, bylaws recommended were a little longer. I took liberty to make some adjustments and changes. They were run by the county attorney. She made some recommendations. Some, for instance, a very detailed way we could do the public hearings if we have some. I asked to be removed because I thought they were a little too detailed and complicated. The bylaws, we can always do that separately by a resolution or at the time we do those things. But she did make some good recommendations on voting amount of people voting and things like that, and we took those to heart. So if you would, I just kind of quickly want to go over. We want to save at least 15 minutes or more for the public, and we still have Mr. Metelsky to speak. So I'm going to quickly go over it, but I do want you to know that I apologize that they were just sent to you today. I don't expect, unless you guys are overwhelmingly excited and want to make a motion to approve them, don't expect it for them to be approved today. I expect them to be taken up at the next meeting for actual approval. That way you'll have a chance to look over them, and if you want to make any recommendations in a knowledgeable and concise way, you'll have time to do so. Or if you have any reasons you want to call me and say you don't like it, you'll have time to do it. Again, if there's no questions, we could move forward. Okay, quickly, the bylaws of the DeKalb County Charter Review Commission was sent to you today. Did most of you have a chance to see it, or did you print a copy if I were to go over it?
Yeah.
Okay. There's Article 1, which is really just referencing the executive order that created us. There's Section 2, which goes over the goals and definitions that were actually laid out in the executive order, which is to ensure the government of DeKalb County is representative of all DeKalb County citizens, ensure that is representative to the needs and demands of all citizens of DeKalb County, to harmonize all parts of the organizational act. D, review the organizational act in light of its impact of the ongoing COVID-19 pandemic and its impact on county operations in order to, 1, identify potential enhancements, improvements in service, delivery, and operational structure. 2, to ensure DeKalb County will be responsive and effective when operating during any future emergency conditions. And E, recommend changes to the organizational act, including recommending the appropriate form of government of DeKalb County in order to achieve the most efficient and effective delivery of services to DeKalb County citizens. Basically, that is all in the executive order. All other things that weren't mentioned there that was in the executive order, we're not discounting, but we wanted to highlight those for the commission and for the public. The third article is basically the officers. Again, the executive order outlines that there will be a chairman appointed by the CEO. That's repetitive of that. A vice chair appointed by the CEO. A secretary that is elected. Now that's Ms. Hinkle. And an assistant secretary, which is also mentioned. And now that we have a secretary, we'll, possibly Ms. Saunders with the clerk's office or another appropriate staff person, probably with the county, will probably fill that role. If we do have a consulting contract, that might be an individual from there, but we'll have that more formally acknowledged at the next meeting, hopefully. And any other officers, if we decide to appoint somebody internally to serve as chair of future meetings or something, we can do so. The duties of the chairperson would be preside at all regular meetings of the commission, set the agendas for all regular and specially called meetings of the commission in accordance with the applicable requirement of these bylaws and law. Represent the commission in all functions, activities are required, but without authority to state any position of the commission, not previous approval. Serve as ex officio member of all committees. Make all committee assignments and appoint all chairs of such committees. Call special meetings where necessary, require. Coordinate public publicity and enforce time limits on remarks of interested citizens in accordance with rules approved by the commission. Again, even those powers, for instance, to set the agenda. If a majority of the commission members vote to put something on the agenda, that would be acceptable, to set the committee dates. Again, the committee, if a majority wants to change what I have laid out, that can be addressed and be done. So duties of the vice chairman to serve and perform the duties of chairperson in his absence or her absence, and the inability of the chairperson to serve, including any period during which the office as chair is vacant. Duties of the secretaries are laid out, and the duties of the assistant secretary are laid out. Okay, on public meetings and hearings, it just reaffirms basically that all our meetings will be in compliance with law and that we'll have public hearings and that we will try to, or we will give notice of the date and time of said public meetings, and that we'll follow all state law. Citizens participation, that we will entertain public comments at each of our meetings, and that comment should be germane to the agenda items, etc. Rules and procedures for citizens participation in meetings or hearing, including reasonable limitations on time allocated for individual citizen remarks or total time allocated to citizen remarks, may be established at the discretion of the chair or by action of the commission. So, and it just talks about meeting locations. Number 4 is call and notice. It states that we've got to have announced meetings, and regular or special meetings shall be posted in the prescribed manner of, again, state law. Scheduled meetings, it mentions that in section 5, it mentions that we will try to lay out 6 months of meetings. That's what I referred to basically earlier when I talked about the first Thursday, is that we'll set those up. If the commission members that later see a need to change one, or we want to have a public forum someday where we think it needs to be a different day, we can do that, but we need to lay out the time so commission members have the best opportunity they can to schedule it, as well as the best opportunity they can to schedule it, as well as the public to schedule meetings. So let's see. The agenda is again laid out in section 6. A standard agenda, call to order, roll call, approval of minutes, introduction of invited guests, report of chairperson, report of committees, unfinished business, new business, remarks from citizens, adjournment. Again, it says that this is generally the way they will be laid out. Anybody recommends some minor changes, we can do it. Certainly the commission members itself at the beginning of the meeting can make an amendment to it, amend the agenda. The majority vote could amend the agenda, adding something. And just want to mention to you all that we're very inclusive. If any of you have anything you want to add to a future agenda, if somebody was adamant that they wanted somebody to come speak on a specific topic, we're going to do everything we can to make sure every commission member has their opportunity to be heard and to have the issues that they want heard. So we'll try to very hard to make any opportunity we can available. Recording of meetings, county's recording meetings, minutes. We've talked a little bit. The minutes are being prepared. Summary of meetings will be done. Voting on section 5, voting. Each member shall be present to vote unless a conflict of interest exists, in which case said conflict shall be publicly stated prior to the vote, filed in writing with the chair. So if you know we're voting on something that there's conflict, you need to address that. 8 members of commission shall constitute a quorum. Yes, this is the time to mention that we do have 2 vacancies. The Senate has 1 vacancy to replace. Originally Candace Rogers was on, but she's on the Ethics Commission. So Emmanuel Jones is working on that. And I believe the CEO has 1 vacancy too that needs to be addressed. The 8 members of the commission shall constitute a quorum for the transaction of business. The affirmative vote of the majority of those present and voting shall be required to agree to any motion except relative to the final report of the commission. To the extent that the final report proposes to add, eliminate, or modify or change any provisions of the organizational act, an affirmative vote of at least 10 members of the commission is required to agree to any such proposal. Quite frankly, we don't want to be referring anything to the legislature unless we have a pretty solid consensus that it's a positive thing, because of course the legislature has to answer the public, and the public wants to make sure that we've studied these issues and have come to some agreement on them. Committees, quorum voting, a majority of members of any committee of the commission shall constitute a quorum. Majority. Proxy voting, there shall be no proxy voting. Article 6 addresses attendance, resignation and vacancies, and billing vacancies basically by any group. If you were appointed by a CEO, your vacancy would be filled by the CEO. Same thing if you were appointee of the Senate delegation or House delegation, et cetera. That next talks about committees and creating or appointing committees. If any of you have any, desire to, look at a certain aspect of this document or other aspects of our work and you think a committee is appropriate, please let me know and we can address that. I will say this, public meetings, even committee meetings are things you have to worry about, public access. And so there's a few hurdles to jump through under this time with COVID to make sure subcommittees are able to meet and have public access, but we'll work with you if any subcommittees are appointed. No committees shall have any final authority to make decisions on or represent the full commission. So if a committee is empowered, they'll be bringing recommendations back to the full committee. And then section 10 just talks about the final report, transmittal of that report, and then number 11, amendments.
Senator Henson.
Yes, Robert.
I have a little bit of angst about Article 9 and the plan of work. That was the only section
I
that
should have went over it.
that stuck out to me. This idea that we might, it says can or may, create a separate group to decide what we talk about, and that raises the hair on the back of my neck just a little bit, because I feel like we could get bogged down with a group of people, not the whole committee, deciding which things we ought to talk about and in what order we ought to talk about them, and that makes me a little uncomfortable.
Yeah, I understand that. And I had a little bit of concern myself, just because you don't want to have things too detailed. You want to be fluid, be able to meet the needs of the commission and getting information to them. But as I looked at it, what I had actually envisioned was that the consultants we have work with us would actually kind of lay out the major topics that we plan to address. And it would be a general plan of work. It wouldn't be too structured for each future meeting. But I would like everybody to look at number 9, and then we may make some revisions on that, because I understand your concerns. And I wasn't expecting a truly detailed layout of the work schedule. So if we don't think we're going to be meeting the intent of that, then maybe we need to scrap it. Mr. Grubiak, I know your official group actually, I think, had included that, because I think they wanted to make sure that from the start there was some outline of what general expectation and work processes would be. Do you have any thoughts on that?
I guess the only thing I would add is that it really just affirm what you just said, that the idea was there may need to be some thought given to how we want to proceed, rather than just starting out on topics that come to mind. So, and that could be the list of issues to be studied could be you doing that. This doesn't say that there has to be a plan of work committee. It just says that a list of issues to be studied and reviewed shall be identified along with a schedule. And you're already doing that in part. The reference to the committee was really, if you decide as chair, you want to create the committee to help you think that through and how you want to schedule things and in what order you want to address certain topics, then that would be a possibility. But there's nothing here says you would have to do that, or that we would be obliged to have another committee. So it's something that's it's a tool that could be used if you as chairman felt it was beneficial.
I think at 1.2, there's so many different areas. I mean, this is going to be a complex work thing. I think it was a concern that they might overly focus on this area or that area, and that if the chair needed input and making sure you really got to the heart and meat of the problem. I think we're going to head there. So I may make some general statements of what I expect the plan to work. And if that doesn't satisfy you, or that you don't think it's appropriate, I should put it that way, then maybe we can look at, revising this section. I want to say this too, once we approve bylaws, if we approve bylaws, that's certainly on to you. And we could operate simply on Robert Rules of Order if we wish. But if we approve bylaws, they are subject to amendments and changes at any time. So if something isn't being properly of service to us all, we can change it. So thank you. Any other questions on these bylaws? I want you to just be prepared next meeting to take action. And if you have things like Mr. Wittenstein brought up on that, if you have any changes or edits you want to email me, I'd be happy to share it with everybody if that's your wish, or at least consider it and get back and have a dialogue with you. So just let me know. Next, I would like to move quickly to Mr. John Metelsky, as he has worked hard to make our commission work by having the Zoom meetings for us. Thank you.
And thank you so much, Mr. Chairman. Appreciate the opportunity. And I will be brief. I've got 6 or 7 slides, but I will go through them very quickly and, of course, avail myself to any questions. So If we look at, I just wanted to give you a brief overview of our department. Our mission, and I'm not going to read everything to you, I will read the mission, is to serve our customers with world-class innovative services and solutions in a collaborative and professional manner. Our vision really is to transform government through innovative and cost-effective technology solutions, and with a focus on economic development, social growth, and efficiencies. And our responsibilities, I'm going to get into in the next slide a little bit more. Here is our functional areas. We support network and telecommunications, computer support, all of the servers within the county, whether they be on-premise or much of which now has been moved into cloud environment. We also, of course, provide IT-related security on all of our systems. We do business applications, consulting and support, procurements and contracts for IT type items, project management, and really to me, and this is why, my office is more about technology and really a focus on innovation. That's why we're called Innovation and Technology. And that's really the IT strategic visioning and planning, where we actually sit down and work with each of the departments and agencies and to identify some of the things that are going well for them, some of the things that we can improve on, the current technology we have that we might be able to leverage to help create efficiencies or make them more effective, or the evolving landscape. And really, that is the focus. We talk about innovation. A lot of people get concerned, oh my gosh, innovation, that must mean expensive. Sometimes it might just be about changing your business process and using a current system and using it better. So bottom line is I really love the focus on the strategic visioning and planning. But again, we do all of the everything there that you see in the functional areas. My org chart's a little bit different. I'm not a big fan of the whole hierarchy with department heads on top or any of that kind of stuff. I'm just part of a team. But really part of our org, everything we do is for our county citizens and constituents. They are really at the top of our chart. We have the leadership of the various, the CEO, COO, the Board of Commissioners, and of course the constitutional agencies. And then my three areas, the IT, innovation and technology departments, three areas that we separate into, but we aren't in silos. And that's why, again, I have that big circle around us, is the software solution support, the infrastructure, as well as I talked about our innovation offices. Wanted to talk to you real briefly. I'm not going to read these, but these are some of the recent accomplishments over the last 12 months. We modernized our human capital management system, moved that up to the cloud. That is an advantage for our current employees as well as pensioners and of course, our future employees. We now have a system that we can bring people in from cradle to grave in terms of their career and have all that information now in one system, and that also again extends to them in their retirement. We also enhanced our 311 implementation with our Oracle customer relationship management system. We added sanitation and roads and drainage, and we continue to expand on that. We migrated 160 on-premise servers to the cloud, both for efficiencies as well as security. I tell everybody anytime I get their ear, Microsoft and Oracle and all these companies spend more on security probably in a day than we could hope to budget for years. So the cloud solutions are really, quite frankly, a godsend. And in this new norm that we have based on the pandemic, and whether it was all remote or now as we look at hybrid opportunities, we want to make sure that we have systems in place where our people can access them, whether they're our employees or whether they're the citizens, can be accessing them 24/7, 365 from anywhere. We also replaced over 800 computers, moving everyone to laptop configurations. That way they can work wherever, remote or back in the office. And so we also did that with desk phones and a couple other things there that you see. At the end of the day, leveraging our taxpayer dollars as well as CARES Act and ARPA funds to really help benefit, making sure our systems are secure, making sure that they're available, making sure that we are doing our best to transform services and encourage engagement with our citizens and constituents. This slide might be a little hard to read, so I apologize. I just wanted to talk to you about some of the awards that we have won recently or in this last year. DeKalb County has been recognized now for 5 years in a row as a top 10 technology-enabled county. This was done by the Center for Digital Government, and in 2007, the county, have been applying for this since 2012. And I don't know if it's coincidental or not, but since 2017, we have been ranked in the top 10. You might want to note that CEO Thurman came into office in 2017. So there, coincidence or not, I don't know. I would suggest that due to him and the administration and the priorities and the annual things, he has really brought together the board, the administration, and the teams to work hard for our citizens to make sure that we're doing what we can. And we started out in 2017 ranked 9th. And last year we were ranked 2nd of all counties our size in the nation. And I believe in July, I'll be able to make another announcement. It's my understanding we have finished in the top 10 again, but I'm not allowed to say exactly where just yet. In addition, we also placed 4th for all counties, and that's, I believe San Diego County was in 1st place on this one. But this is for our County Government Experience Award. And really that takes into account our website, our social media, everything that we do to create transparency, to create access, to create engagement opportunities for our citizens and constituents. And again, that was 4th for all counties. So such an honor to be recognized. I'm so blessed to have a great team that I work with and an administration and a board who have the vision and have been providing the support. Couple of those other things are there. I have also been honored thanks to appointments. For those of you, you probably know that Commissioner Larry Johnson is president of NACO this year. I have actually been on a chair or vice chair with NACO for a couple of years now, moved up to the chair of the NACO Technology Standing Committee, as well as the vice chair this year of the Technology and Telecommunications Committee. And just some great work. DeKalb County is getting engaged and involved, helping with broadband expansion and really just chiming in both legislatively in terms of making recommendations on legislation changes at the federal level and those kinds of things. And all of that, again, is brought on because of the fact that DeKalb County is a recognized leader in the technology area. And again, we've been that now since 2017. As we look at our goals for this year, and again, I'm not going to read all of these, we're doing some website enhancements to ensure that we continue to expand and we're not going to rest on our laurels. Quite frankly, we're not number 1 yet. I want to be number 1. I know the CEO and Zach and everyone else wants to be number 1. Number 2 is okay. Some might consider it first loser. I don't. But no, we're just excited about the progress that we have made, and really we are going to continue that progress and until we're number 1. And our goal, of course, is to always be the best at what we do. And then, everything that we do, a lot of folks think that IT, oh, that's just a back office, a thing. And, it's in some cases years ago, it might have been considered a necessary evil. It's really been an honor to work here at DeKalb County now for just shy of 10 years. September will be my official 10th year. And I've had the opportunity to work in 3 different, over the last 24 years actually, in government, worked both in a strong mayor form at a city in Florida, also worked in another Georgia county who had the Board of Commissioners with the county administrator. And then here, of course, with the elected Board of Commissioners, elected CEO, and the executive assistant, county executive. What I will tell you, I've had great experiences at all 3. CEO Thurman and the administration has really allowed for me and the entire technology team to focus on driving innovation. He has really created the question to me isn't really so much about the form of government. It's more about the leadership that you have in those positions within government. And CEO Thurman, Zach Williams, and the entire administration have really created opportunities for all of the department heads to excel, created opportunities. The Board of Commissioners have done the exact same thing. None of them are looking for yes people. They're really looking for honest opinions, and my engagement has been not just in technology initiatives. Again, we're striving for innovation and technology, and I have definitely been given the opportunity to excel and contribute and engage on a variety of projects, most having some technology ramifications, but it's not all about the technology, as I mentioned earlier. It really is about getting in deep with the customers, with the different departments and agencies, looking at their business processes and ensuring that as the time evolves, as we continue to move forward into 2022 and beyond, that we're not sticking with old business processes and old technology. But we don't want to do old business processes and new technology either, because then we're able to do things potentially quicker, but not necessarily more effectively or efficiently. You've heard the old adage, garbage in and garbage out. Well, we want to ensure that we're doing it right. And so that really is what our focus has been. And again, been given the opportunity through the vision of the board, the vision of the CEO, and the support and leadership. I think our success overall really has been dependent upon the result of the engagement that we get from the CEO, of the COO, as well as the Board of Commissioners, the support and the trust that we have with them, and just the ability, they give us the ability to do what needs to be done. We don't like to make mistakes, but when mistakes occur, we learn from them, we get the support, and we move forward. So I will turn it back over to you, Mr. Chair, for any comments or questions that you all may have.
Thank you so much. First, I'd like to have Zachary Williams make a comment about your department.
Thank you very much, Senator Henson. And I appreciate the opportunity just to make a brief comment and really piggyback on what Director Metelsky has said, and give a kudos to John. His leadership has been tremendous. It was no accident that DeKalb County is had been ranked number 2 among large counties throughout the nation, and number 4 among all counties throughout the nation in our IT performance. So when we look at looking for best practices and trying to find where efficiencies are and are not, agencies come to us and they want to do what we are doing. And it's because of John's steadfast leadership, his commitment. Over these past 2 years, he has hosted thousands of Zoom calls, helped us transition from people waiting in line to working online. And so I can't say enough about what Director Metelsky and his team have done. And this is speaking from a person who's been at this about 30 years in 3 different states. John, I think he gets shortchanged when he's number 2, because we are the best in the nation. Thank you.
Thank you. He's been a great help to us getting these Zoom meetings. Is there anybody, I know normally we like to grill the directors and department heads on who hired them, who fires them, and how they like their job, but you did cover up pretty well how successful you think you're doing, and we really appreciate that. Is there any questions that need to be asked of Mr. Metelsky?
And Mr. Chair, while anyone's thinking about that, you may have Ms. Leek somewhat to blame. Although she was not responsible for hiring me, she was responsible for getting everything once I was in that process for getting me in here. So she deserves either some of the blame or some of the credit.
Definitely be credit. Thank you. She's done a lot for our county. Well, thank you so much, John. We really appreciate it. We appreciate you rushing through that. I know it was much quicker than you wanted, but I think it's been a very good meeting. I would now like you to manage the controls and see if any members of the public, we're going to open up to public comments. We would like to reserve, time for everybody. So if you keep your comments about 3 minutes or less, we would like to go from there. Thank you.
Absolutely. And thank you, Mr. Chairman. Yes. And for those of you that would like to provide a public comment this evening, again, please keep your comments to 3 minutes or less. Of course, no profane or derogatory comments, and we'll open up the floor now. If you would like to speak, use the raise hand feature, or if you are on a phone, #2 will get you there as well. Our first speaker request is from Stephen Binney. I will ask Mr. Binney to unmute. If he would like to start his video, he may, and please state your name and address for the record. Mr. Binney, you are unmuted.
Stephen Binney, 1083 Seville Drive, Clarkson, Georgia, 30021. Good evening, Charter Review members. Welcome back. It's been a long 3 years since our first meeting. I want to start off by thanking you for taking part in the most important process DeKalb County will be going through in over 40 years and letting your opinions be known to the public. Over the last 40 years, DeKalb County has told us what to do and how to do it. Now you have the opportunity to suggest changes to DeKalb County and how they will do things in the future. Please do not waste this opportunity, my friends and neighbors. Do we want more districts, and do we want to keep super districts? Do we want to change our CEO form of government? Would we like NPU-style neighborhood entities to establish a more localized line of communication? The most important question to start out with is to ask, do we want to remain the only county in Georgia with a very powerful CEO and weak commissioner form of government, or do we want a more equitable distribution of power in DeKalb County? Because CEO Michael Thurman is elected, members of the county commission are not currently empowered to evaluate his performance. DeKalb County is the only county in the state that has an elected chief executive officer who manages daily operations, leaving the county commission to try to make policy decisions and approve CEO decisions. A committee which included lawmakers from across the state met for several months before this charter review process first began, and its report included criticism of DeKalb policies allowing the CEO to veto county commission actions while retaining nearly absolutely control over employees and the budget. Such limited authority of the commission undermines any political balance between the CEO and the commission in this type of government structure, the report said. There has been a history of this power being abused in the past, and unless this governmental structure is changed, the possibility of misuse of power will continue to exist into the future. How many commission districts should DeKalb County have? 7, 9, or more? Should we maintain super districts or not? I personally like 9 districts, 7 individual and 2 super districts, but your preferences may be different, and now is the time and place to voice your ideas and concerns. 7 individual districts will still give each commissioner over 100,000 citizens to represent, which is still a lot. Perhaps the formation of something like the NPU units currently being used in the city of Atlanta, would be a way to bring people closer to their government, as well as bringing the government closer to its neighborhoods and citizens. I realize there are potential problems with too many levels of government process, but I do know that under our current governmental process, that communication and transparency with the people of DeKalb County are sorely lacking, and the power to change or reverse a decision by the CEO is non-existent. I did want to state that perhaps ranked voting, if it would be allowed by the state of Georgia, would be a way to get your 50+1 without having 8% turnout in runoff elections. And I want to thank all the committee members for taking the time and making the commitment to improve our county government. Also, with the 2 openings, I give my name to both CEO Thurman and to Senator Jones, as I have great interest, and you have known that I've had great interest in serving on this committee for a long time. Thank you for your time and consideration. You all have a great evening. Thank you.
And thank you for your comments, Mr. Binney. Our next request is from Charles Henkla. I will ask him to unmute. If he would like to start his video, he may. And please state your name and address for the record.
Hi, Charles Henkla from Georgia State University. My address is 1837 Meredith Drive, Atlanta 30318. Apologies that it's in Fulton. I hesitated to mention it for that reason. So I just wanted to make a brief comment on Mr. Wittenstein's excellent point about the majority voting. And actually, I was kind of scooped by Mr. Binney just a moment ago. And I wanted to encourage you all to consider ranked choice voting as an option. I know there was some debate around whether the state requires the counties to have majoritarian elections, and I'll leave that to the county attorney to research. I have no idea, but even if it does, ranked choice voting might actually be a way to kind of thread the needle, essentially to allow the county to maintain a majoritarian electoral system where the candidate wins 50% plus 1, while simultaneously avoiding the extra expense and the turnout problems of actually holding a physical runoff. You could have essentially an instantaneous runoff. And this is a system, as a comparativist, This is a system that I can tell you works in a number of countries. Australia, most notably, uses the system. And actually, there are several states that use it for their state elections now. And so it's something I think at least to consider if it's compatible with state law and local law. So thanks again. This was a really fascinating meeting, and I really enjoyed listening in on it.
And thank you for your comments, Mr. Hankla. At this time, Mr. Chair, that exhausts the current requests for public comment.
Thank you so much. I want to again thank all the commission members for their time. I think it was a very rewarding meeting, and I want to thank again the county attorney for her efforts, and always glad to see the CEO and the COO staying with us too. Want to remind people that our next meeting that we discussed previously will be on Wednesday, July 20th. Then our expected meetings, our scheduled meetings will be first Thursday of the following months, August 4th, September 1st, October 6th, November 3rd, and December 1st. We can discuss and update that list as we progress, but I certainly appreciate you being here, and I look forward to the county attorney bringing us some more good information, and I think that's the way it should be. It's not going to be an easy or fast task, but I'm certainly learning things, and I'm sure you are too. Thank you again.
Mr. Chair, Ms. Leak has her hand raised.
Yes. Ms. Leak?
Yes, just a quick question. At our last meeting, we had a very good presentation from Mr. Scott on his department, and then this one for this evening. I'm just requesting that these be put on the website as well under the documents section of the commission's website.
Claudette, I'm going to follow up with all of them and make that happen.
Thank you.
Okay. Yeah, and of course, the entire meeting, including the slides shown here, will be in a video recording that will be on the county website. So the ones that he showed us and everything we saw will be part of the public record, which is attainable on the county website. So thank you. And I did want to see if there's any other comments before I take a motion to adjourn.
Mr. Chair, just real
Yes.
quickly, I'll just share and piggyback on Ms. Hinkle's comment. We have a website currently, and we'll work with Ms. Hinkle to ensure that all the data continues to be posted, as well as the recordings of each meeting. That should be up by noon the day after each meeting.
Thank you. And you think there's a good chance we can get the minutes a week before the meeting, so people
Absolutely, yes. Because and we're going away from the transcript to a more traditional minutes. You'll definitely have those well in advance.
Mr. Williams, I really think it would be great to get documents 72 hours before the meeting.
Absolutely. You'll have them more than that. It's just that this past meeting, a lot of the documents were developed yesterday, I believe.
Right, I understand. I appreciate that. Thank you.
And sometimes that's my fault too. I was waiting for some revisions. So thank you. Thank you all. I'll accept a motion to adjourn if there's no more comments. Nobody wants to adjourn? We can.
So moved. So moved.
Thank you. I'll take that as a motion in a second. Hearing no objection, thank you again for your time. Goodbye.
Thank you.
Thank you.